And go live.
Welcome back to House Education on Wednesday, April 23rd, 2025. We got some time, so we're doing a bill introduction, H497. It is a short form bill, so it's going to be a short presentation. However, I've asked Legislative Council to sort of go first to sort of talk about what this means and what it connects to in statute. All yours.
Sure. Beth St. James, Office of Legislative Counsel. Do you want me to share my screen?
Sure.
Okay. So we're looking at H497 as introduced. This is a short form bill. Have we walked through a short form bill before?
I don't think we actually have.
Okay. So you should all remember from your orientation that short form bills are just the statement of purpose. So the statement of purpose in this bill proposes to require approved independent schools to comply with the school-sponsored media freedom of expression rights for students contained in 16 VSA 1623, and we can look at that. It also proposes to require all post-secondary schools operating in Vermont to comply with the school-sponsored media freedom of expression rights for students contained in 16 VSA 180. This is the post-secondary version of the 1623. So it's just the statement of purpose. You'll see there's no in the bill title, an act relating to student freedom of expression rights in school-sponsored media and approved independent schools and post-secondary schools. And then it says text omitted in short form bills. There is nothing. So if you were to take this up, you would actually have to do the work of amending the statutes themselves. Where would you like to go from here?
I'd like to have you talk to us about 16 VSA 1623.
Please.
Okay. So, 16 VSA 1623 lives in chapter 42 and title 16. The chapter of that title is student rights. The only other piece of law here is the school library material selection policy. So the section starts with, so this is for public schools. This is only applicable right now to public schools. And you can see that because it says school means a public school. So it starts with some intent language here, or some policy purpose language. So the General Assembly finds that freedom of expression and freedom of the press are fundamental principles in our democratic society, granted to every citizen of the nation by the First Amendment and then our state constitution in Chapter 1, Article 13. These freedoms provide all citizens, including students, with the right to engage in robust and uninhibited discussion of issues. And the General Assembly intends to ensure free speech and free press protections for both public school students and students of public institutions of higher education in the state, in order to encourage students to become educated, informed, and responsible members of society. There is quite a bit of case law related to the First Amendment in public schools. I am not prepared to dive into that today, but should you want that presentation, I'm happy to give it. What this statute does is it tells schools what they can and can't prohibit. So we've got some definitions. So media advisor means an individual employed, appointed, or designated by a school or its governing body to supervise or provide instruction relating to school-sponsored media. School's public school, school-sponsored media means, and these terms are actually quite important when it comes to the case law involved here. School-sponsored is your key term. Means any material that is prepared, written, published, or broadcast as part of a school-supported program or activity by a student journalist and is distributed or generally made available as part of a school-supported program or activity to an audience beyond the classroom in which the material is produced. So your school newspapers, your morning news, etc. Student journalist and student supervisor. I think you all can read those. So subsection C, we start what is okay and what is not okay. So subject to subsection E, a student journalist may exercise freedom of speech and freedom of the press in school-sponsored media. This subsection shall not be construed to be limited by the fact that the school-sponsored media are supported financially by a school or its governing body, or by use of facilities owned by the school, or produced in conjunction with the class in which the student journalist is enrolled. Student supervisors of school-sponsored media are responsible for determining the content of their respective media. And a media advisor may teach professional standards of English and journalism to student journalists. So here are the exceptions. This section meaning the entire statute, shall not be construed to authorize or protect content of school-sponsored media that is libelous or slanderous, constitutes an unwarranted invasion of privacy, may be defined as obscene, gratuitously profane, threatening, or intimidating, may be defined as harassment, hazing, or bullying, violates state or federal law, or creates the imminent danger of materially or substantially disrupting the ability of the school to perform its educational mission. This is all taken from federal case law around the First Amendment and freedom of expression and speech and press in public schools. A school is prohibited from subjecting school-sponsored media other than that listed in E that we just walked through to prior restraint. A school may restrain the distribution of content in student media described in subsection E, provided that the school's administration shall have the burden of providing lawful justification without undue delay. So the burden is on the school. Content shall not be suppressed solely because it involves political or controversial subject matter, or is critical of the school or its administration. A student journalist may not be disciplined for acting in accordance with this section. A media advisor may not be dismissed, suspended, disciplined, reassigned, or transferred for taking reasonable and appropriate action to protect a student journalist for engaging in contact protected by this section, or refusing to infringe on conduct that is protected by this section, by the First Amendment, or by the Vermont Constitution. Each school or its governing body shall adopt a written policy consistent with this statute, and no expression made by students in school-sponsored media shall be deemed to be an expression of school policy. This is largely the same in section 180 for post-secondary schools, public schools. And so what H 497 would do is add independent schools here.
Could you scroll to the bottom? I just want, curious as to what year this all was done.
Very recently, 2017.
Yes. One would think I would remember doing this. I think I have digital dementia. It's coming for all of us. All right. Emily, you have
No,
recollection?
I was thinking.
We were there together.
I'm not, were you?
2017 was my.
We would have been our first year. That's
Yeah.
not your first year and my second thing. I mean, I don't remember it.
Yeah.
I really
It's
don't.
only 8 years.
All right. And you say that the other, the
Yes,
section 180, is it
180,
basically
I'll
the
just,
same thing.
I'm just looking. It is exactly the same.
Yep.
For post-secondary school. So school is, means a public post-secondary school operating in the state. So 497 would add, any, so that would include the privates.
Is there any case law that references 1623 or 180?
Oh, that's a good question. I don't know. I'll look into that.
Okay. It seems so new that it probably
I'll look into that.
doesn't, but I just sort of am wondering about, like, can we really tell a private college
Oh,
how to?
yeah. Yes,
operate?
you can. If they want to be allowed to operate in the state, you can put some restrictions on that. California has, I believe, the most protective law out there related to the protection of First Amendment rights in schools, and it applies to both public and private, and it's been around for decades.
Yeah.
So I can look at some of the challenges to that. And certainly if you're tying any sort of state funding, like public tuition, you can certainly put parameters on that. The First Amendment, because public schools are the government, right? the government is not supposed to be censoring speech, right? The First Amendment, your Bill of Rights apply to government action. It does not necessarily, and generally speaking, apply to private actors, right? So that's where, when we talk about what's okay in a public school versus a private school related to the First Amendment, it may look a little different on a pure First Amendment analysis on what schools can censor and what they cannot, or what they can prohibit, or what they can't. Because public schools are the government and they are constrained by the First Amendment, but private schools are not the government. And so their ability to prohibit speech or action is different. But you, as the state government, can put laws in place that hold them to higher standards. That's a policy choice that is available to you. But yes, I will, sorry.
I wonder if there are other examples of areas where we have done this with, and I'm thinking only of post-secondary, private schools, private colleges.
I will look into it. I'll look into it. I mean, your hazing, harassment, and bullying prevention policies, all schools, all
Yeah.
public and private are required to have those.
Post-secondary, do we have?
Yes,
Yeah, okay.
Yep. I mean, Title IX is gonna also
Mhm.
come into play here, and that's in federal law. That's tied to the receipt of federal funds, which most, not all, most post-secondary institutions do receive some amount of federal funding. But I will look for that.
So how does it stand today? If I'm a publicly tuition student going to an approved independent school, do my constitutional rights follow me there? Or is that,
It's the setting and the actor, not the money,
okay,
not the source of funds.
or like, right, okay.
So I guess I'm assuming that this is where this is coming from. Have there been situations?
A
Okay.
good time to try.
Good,
and
good,
get
good,
students.
good.
Why don't we do that?
That's what I want to hear about.
Thank you very much, Beth.
You're
Thank
welcome.
you. That teaches journalism. We have
Mm.
native problems. Yeah.
Good morning, Representative Casey.
Good morning, everybody. It's a pure pleasure to be in the Education Committee. Haven't seen the room yet, so
Oh,
I was saying I'm in institutions and we've got one of the worst rooms, even though we build stuff. So, thanks very much again for having me. Connor Casey, I represent Montpelier. I see my district mate's not here. I planted some softballs with her, but that's okay. And I do want to thank everybody for the opportunity to introduce this short form bill here. As you've heard from Legislative Council, it would extend First Amendment style protections to student journalists and all Vermont institutions, including independent and post-secondary private colleges. And I was gonna thank this committee because you did make real progress in 2017, whether you remember it or not, in passing what was called the New Voices Law to protect student journalists in public schools and colleges. But the law doesn't extend to private universities or institutions, and recent events have really brought this contrast to light here. And, I'm not going to beat around the bush. I'll be totally candid. I was asked to introduce this bill by students at Norwich University. Some of them are constituents, some of them are alumni, and I sat down with them. And I'll be honest, I was pretty shocked with what I heard. I had read about it a little bit, and I don't purport to have firsthand knowledge on this, but I think it's worth having some curiosity and exploring what happened here, because I'm told that, Vermont's oldest private college here. For years, the students have published stories on topics that matter to their peers and their community of Northfield, everything from sexual harassment investigations to campus safety concerns. But this fall, I was told that university administrators blocked students from printing certain stories and restricted their online publishing access. The students were instructed to seek administrative pre-approval before publishing any of these stories. And to me, that's not journalism. That's public relations when an administration can dictate what their students say. It definitely occurred to me, some of these are cadets, they're looking to serve our country and everything. And what sort of message does this send if we're really clamping down on this, like so early on and, you know, when they're young students here? I think it's an erosion of civic education. If students are unable to report on the real issues without fear of censorship, they're going to lose a key opportunity to practice democracy and accountability that, you know, in this case, I think Norwich values were founded on, right? So H497 simply ensures that students at these institutions have the same rights as those in public schools to speak freely, report responsibly, and learn without interference. And I think, like, you know, if you fleshed it out, I would also ask that you look to protect faculty advisors. If you look at the Norwich case right now, it just came out that the advisor for this student newspaper in Norwich is suing the university there. And it'd be interesting to look at the case as it's laid out there. So it's a straightforward fix, puts all Vermont students on equal footing, and it affirms that censorship just really has no place in these institutions for our future citizens. You know, I think as we look around the country right now, you do see like editorial boards maybe being influenced by money or other interests. And you know, we just want to set the record, you know, we want to set the record straight that this should apply to everybody here. A couple other states, I think, that recently adopted this, New Jersey and Illinois, passed protections for private colleges. And yeah, I think, you know, it came up, but if public money is flowing into these institutions, public transparency should flow into them as well. And, you know, we really should be empowering our student journalists here. Again, just transparent, I'm mostly familiar with the one situation. I haven't really thought about independent schools at the secondary level, but I don't see why they shouldn't apply, just like public schools here. So that's it for me. Happy to take any questions. I'm not an expert, but I really think whether it be this bill, I think the education, it warrants looking at this issue right here. It was really concerning to me when I sat down with the students and heard what was going on.
It's fascinating. I'd forgotten about the Norwich stuff. I only read the headlines and dived into it too deeply.
And they'd be glad to come in. The students, they said, the professor there who has recently been shifted from the newspaper to, entry level English class there. He feels like he was discriminated against.
Fascinating.
Does this bill also prevent like the government from taking action against a student for publishing something in a student newspaper?
I think so. As legislative council just explained, like public school is government. So one could say in that setting, yes. But if we were to take a private college, I'm going to guess that the government would be hemmed in by the First Amendment. And we're living in a different world right now, but could the federal government take away public dollars from a private college because of something that was published? I think we're seeing that happen right now.
Or could they, like, I don't know, retaliate against a student from writing an op-ed and respond to?
Certainly,
We've seen that happen too.
I mean, in normal times, that would probably not be allowed. Because
But-
that would be a violation of First Amendment rights.
Right. I'm wondering if this bill does anything to protect that, but it doesn't. It sounds like that's a separate issue.
I think it makes very, it's a good question for legislative council. If we delve deeper into this, but I think it does provide those protections.
Okay.
And I would just say, you went over some of the language. It also, like, it doesn't open the door for slander or anything.
Yeah.
Libel. It's and it's been spelled out pretty clearly there.
Well, it's existed for public schools and public colleges for almost 10 years at this point. Yeah. And I would just remind the committee that we also have recognized independent schools that are different than approved independent schools that are different from approved independent schools that are qualified to receive public tuition, but that's a discussion for another day.
Yeah.
Great. That's a fascinating topic. Thank you very much.
All right. Thanks very much. Yeah.
Thank
Hope you have a great day.
Thank you.
Again, why don't we take 7 minutes and then we'll set back up for